This paragraph is trying to convert investigative discretion into a constitutional obligation. That's the core flaw. Let's go point by point. Number one, requested that officers review available video evidence. Police are not required to review unlimited digital material simply because a complainant demands it. What they are required to determine is there probable cause? Is there articulable suspicion of a crime? If officers responded to the scene, interviewed parties, observed conduct directly, assessed contemporaneous behavior, determined no crime occurred, they are not constitutionally required to later conduct a full forensic review of hours of internet footage. Courts consistently recognize investigative discretion. Officers decide what evidence is necessary to determine whether a crime occurred. If the alleged conduct, public filming, online speech, range videos, is facially lawful, reviewing more footage does not change the legal threshold. Number two, requested that officers contact defendants. Police are not obligated to contact someone engaged in lawful conduct. If there is no probable cause, no articulable threat, no statutory violation, there is no duty to conduct a warning interview or confrontation. Law enforcement is not required to mediate interpersonal disputes unless a crime is implicated. Declining to contact someone about lawful public filming is not constitutional misconduct. Number three, document as a connected series of escalating events. This is rhetorical framing. To turn separate incidents into a criminal pattern, the conduct must satisfy statutory elements such as repeated unwanted contact, following, credible threats, conduct causing serious emotional distress without lawful purpose. If each incident independently involved public filming, occurred in public spaces, contained no threats, contained no brandishing, involved reciprocal engagement, then labeling them a pattern does not create criminality. Police document what they observe and what fits statutory elements. They are not required to adopt a complainant's narrative theory of escalation. Number four, constitutional reality. Even if officers decline to review footage, decline to contact defendants, treated incidents as isolated, classified disputes as civil, that still does not create Break 1983 liability unless there was a clear constitutional duty, the failure was deliberate, it was caused by policy, and it resulted in a constitutional injury. There is no general constitutional right to have police investigate the way a complainant prefers. Number five, what a court will focus on. A judge will not ask, did officers follow plaintiff's investigative requests? The judge will ask, was there probable cause for a crime? Did officers knowingly ignore criminal conduct? Was there a policy encouraging non-enforcement? Was plaintiff deprived of a constitutional right? If investigations occurred and no crime was found, the disagreement becomes subjective dissatisfaction, not constitutional deprivation. Number six, what series of events? That's the right question legally. To establish a criminal pattern, there must be statutory stalking elements, true threats, menacing conduct, trespass, obstruction, harassment under defined elements. If each event was independently lawful, stacking them together does not automatically convert them into unlawful conduct. Police are required to investigate credible allegations of crime, determine probable cause, act within statutory authority. They are not required to conduct unlimited video audits, confront citizens engaged in lawful conduct, reframe civil disputes as criminal patterns, arrest absent probable cause, provide personal protective services. If documentation shows they responded, assessed, and made reasoned determinations, this paragraph is unlikely to create municipal liability. If you want, I can walk through how this would likely be addressed in a motion to dismiss versus summary judgment. They're slightly different strategic approaches.